Zuerst möchte ich sagen, dass es mich freut, wieder in Südtirol zu sein. Meinen Dank möchte ich insbesondere an Christian Coleman aussprechen. Et bonjour Eva. Quelques mots en français. Mesdames et messieurs, je tiens d'abord à vous dire le plaisir d'être de retour au Tyrol du Sud et de vous remercier pour votre chaleureux accueil ici à Bozen et d'exprimer en particulier ma reconnaissance à Christian Coleman et bien sûr à Eva. Et je poursuis ma communication en langue anglaise pour donner la suite à la demande de Christian. To begin with, tell me that I'd like to tell you that I found very interesting that you have chosen this topic and that you've decided to discuss an issue that I realize had not been very much discussed in the scientific literature, in international law, in European law, or in constitutional comparative law. There are very few things that have been written on the issue of dual or multiple citizenship in relation with minorities. There's been a lot of discussion about citizenship, European citizenship, national citizenship, but on this topic, there is very little literature. So this conference, I think, will be very useful to understand much more about this linkage between protection of minorities and citizenship as a concept itself. And I've been asked to look into issues of international law, of European law, and I will also at the very end of my presentation talk about some issues of constitutional law. And I understand that my colleague from Innsbruck, Peter Hilpo, will also discuss international law issues, so I hope I don't say everything that needs to be said on these issues. And I prepared a very short document to present you some of the treaties and instruments that are very relevant to our debate, and there'll be a very good and well-documented paper that I will give you later. So when it comes to the right of nationality and dual citizenship of persons belonging to minorities in international law, it's very important to know that there is, in international law, a right to nationality. That can be very surprising, but as soon as 1948 in the Universal Declaration of Human Rights in Article 15, there was a statement that individuals, citizens, had a right to nationality or a right to become citizens, to have a nationality. Well, that is something that states have, in a sense, implemented, because in most constitutions there are provisions that determine how you obtain that right, or if that right is given to you by birth or by filiation, or if it can be obtained by naturalization. But it's interesting to note that the idea of nationality has been, as soon as 1948, elevated as a right, as a human right, a right to nationality. And there is in the European Convention on Nationality something that's equivalent, although it's not exactly the same, because in that convention it's only said that countries should recognize a right to nationality. It's not a right recognized by the convention itself. It's a commitment made by states to recognize such a right if they become members to this or parties to this convention. It's framed in a different language than the Universal Declaration of Human Rights. The issue of nationality in international law has mainly been discussed through the issue or the implementation of this notion of diplomatic protection. And you'll see how relevant it is in this matter, because the condition, or one of the conditions for the exercise of diplomatic protection, is that the country that wants to exercise that protection must prove that it's exercising it concerning one of its nationals, one of its citizens. And that is something that has been recognized in some conventions and case law of the Permanent Court of International Justice, the Court of International Justice, and also in the jurisprudence of the European Court of Human Rights and even of the Court of Justice of the European Union. But there's also a limitation, which has been considered for some time as even part of customary international law, which means that you can exercise a protection for your own nationals, but if there is dual nationality, you cannot exercise your diplomatic protection for a national in another country if that person also has the nationality of that other country. So, for example, applied to the case of South Tyrol, for example, even if our friend, I think there wasn't one of our friends here who has dual nationality, the lucky man, well, he could not claim in Italy the protection of Austria for something, a right that would have been breached, because he's also a national of Austria. And that rule was entrenched in that very old 1930 Hague Convention on certain questions relating to conflict of nationality in its Article 4. But that rule seemed to be evolving because very recently in 2006 the International Law Commission drafted an article which is not yet law because there is no convention on this issue, no universal convention, that said, well, there might be now a possibility to exercise your diplomatic protection if your nationality of the country that wants to protect you against the country of your other nationality is predominant. So the law is evolving, which would allow protection of a national in the other state of which you detained a nationality if the nationality you have is predominant, which means that probably you'd have to live in the other state, be domiciled, and have most of your activities in the other state. So that's an important issue when it comes to nationality and dual nationality, the issue of diplomatic protection. I've looked also into the instruments, treaties, declarations of United Nations and in other bodies relating to the protection of minorities and protection of national minorities. And I don't know if I should have been surprised, but the issue of nationality is not even discussed, is not even mentioned in treaties or instruments. For example, in the UN Declaration on the Rights of Persons Belonging to National or Ethnic, Religious, and Linguistic Minority, the word nationality is not even in this document. So there's no reference to the idea of nationality, the right to nationality, or the dual nationality of persons belonging to minorities, which is in also the case in the European Framework Convention on National Minorities, to which both, I verified, Italy and Austria are party. There is no reference to nationality and to the acquisition of nationality, or the idea that countries in which there are national minorities and countries that have as neighbors countries where there are people of the minority of the language or ethnic background of the country, that they should grant dual citizenship. So when it comes to international law, there is very little concern, obviously, for issues of nationality when it comes to minorities. There is one, I've discovered one interesting thing, in fact, is that there is a document adopted in 2008, I guess it was here in Bozen, these recommendations on national minorities in interstate relations, which is a document that's very interesting because it does suggest that the issue of dual nationality when it comes to minorities is not seen as a very good thing to happen. And I'll just quote you recommendation 11 of this instrument, which says, and you'll see why I come to the conclusion that it seems to be an issue that disturbs countries and countries that have been I guess, asked to deal with this issue. Recommendation 11 reads as such: states may take preferred linguistic competencies and cultural, historical, or familial ties into account in their decision to grant citizenship to individuals abroad. States should, however, ensure that such a conferral of citizenship respects the principle of friendly, including good neighborly relations and territorial sovereignty, and should refrain, this is the key sentence, it should refrain from conferring citizenship en masse. It's in French in the text, en masse, even if dual citizenship is allowed by the state of residence. If a state does accept dual citizenship as part of its legal system, it should not discriminate against dual nationals. So you see there is this reluctance to deal with this issue of dual citizenship. It's not prohibited, but the idea is that countries should refrain from conferring citizenship en masse to persons belonging to national minorities in neighboring countries. So that is partly what international law says and European law when it comes to the law made by the Council of Europe with the European Convention. Let me just quickly discuss and bring two other issues to you. The issue of nationality, dual citizenships in European Union law and in constitutional law. Well, it's very interesting to see that most of you are dual citizens because of the law of the European Union now. You have a nationality, but you also have, because of that European nationality, the citizenship of the European Union. And that seems okay. That doesn't seem strange or unacceptable. So in a sense, it also provides national minorities and persons belong to minorities to some rights, because as members or as citizens of the European Union, that comes with rights that are both in the Treaty of the European Union, the Treaty of the Functioning of the European Union, and also the Charter of Fundamental Rights of the European Union, and especially Article 22, which says that the Union shall respect cultural, religious, and linguistic diversity that can, I think, be interpreted as conferring rights to citizens of the European Union belonging to national minorities. That article has not yet been implemented a lot by the European Union, but it could be. It could become a key, it could have a key role in the protection of minorities within the European Union. I'm sure the Court of Justice of the European Union might be open to giving it a wide interpretation. And let me end in talking to you a bit about constitutional law, and it is a matter of that would entail extensive research to look in every constitution. If constitutions deal with the right to nationality and dual citizenship, some do, some don't. Some do deal with the issue not in the constitution but in legislation, like in many countries, including Canada, for example. But there are some constitutions that accept the idea of dual citizenship, and there is a practice of dual citizenship, including for minorities.